Good morning. Today, after sharing the Supreme Court judgment, I would like to draw your attention about the geographical scenario when our India was declared independence in the year 1947, and we strained to enact a constitution and brought into force in the year 1950, 26 January 1950. During that time, there were several independent states which were under the agreement arrangement with the British government, French government, and Danish government. So the Portuguese government also, Goa. So that resulted later on due to the ironful hand of Sardar Vallabhbhai Patel, we are able to bring all these samasthanas under our control. Thereafter, problem arose how to run high courts at various provinces. Earlier, there were Central Province, Bombay Province, Kolkata Province, and Madras Province, and Central Province, Northeastern Province, Western Province. So these problems were there. Therefore, what had happened due to the local leaders, regional language leaders started agitating that they want independent state, they do not want under the same province which were constituted and controlled by the British people. So initially the Prakasam started a hunger strike for Andhra Pradesh independent state. That resulted Parliament to enact States Reorganization Act 1956. After enacting 1956, the Act says 51(3), the High Court can arrange for additional place of sitting of High Court. Therefore, what had happened at Goa and several places, you see Nagpur, an independent High Court was there at the Central Province because Nagpur was capital of Central Province. Therefore, Bombay High Court has approved that the bench at Nagpur will be permanent bench. Then Aurangabad, Madhya Pradesh. Then so many Goa, Panchim. That was also. Then what had happened? Kolhapur was independent state. Thereafter it was annexed with India. Therefore, earlier what had happened, when British people initially appointed Supreme Courts at all Delhi, Bombay, Calcutta. In Madras also, when you had an occasion to visit first floor of our High Court premises, you can notice the name of the judges, the Supreme Court of Madras. Thereafter, it is brought under being High Court. Because when that was the Supreme Court, then there was a federal court, then there will be a privy council, subject to final decision of the British people. Now we are independently having Supreme Court. That is Apex Court. What had happened, an advocate has challenged when Bombay High Court judge has established a sitting bench at Kolhapur. So that was challenged, stating that the decision of the Chief Justice is not with the consent of full court. Then they say he has no right to constitute permanent Solapur High Court. So many constitutional questions were raised by him. So that all these things were answered. This is AR 2026, Supreme Court 181, AR 2026, Supreme Court 181, Ranjit Baburao Nambalkar versus State of Maharashtra and another. Then they say notification appointing Kolhapur as place where judges and division court of Bombay High Court may sit. Legality. 51(3) confers an independent continuing power upon Chief Justice High Court, exercisable within the approval of Governor to appoint additional places of sitting for more convenient transaction of judicial business. Exercise of power under 51(3) neither amount to establishment of permanent bench nor result in territorial bifurcation of High Court. Longevity of sittings at such places does not confer arrangement into one under section 51(2) permanent benches. Further, full court consultation is not statutorily mandated under 51(3). Chief Justice administrative decisions represent institutional will of High Court. Selection of Kolhapur was based on rational consideration of distance, accessibility, convenience, and vision of bringing justice closer to people. Mere existence of demand from other regions does not render the decision arbitrary or discriminatory. Notification appointing Kolhapur as place where judges and division courts of Bombay High Court may sit was proper. You know what happened when Madurai court was constituted? Because that time Subhash Chandra Reddy was the Chief Justice, a fantastic Chief Justice, amenable to all. Due to the agitation of the advocates, he was victimized, transferred to Kerala High Court. He could not be elevated to Supreme Court. That time I was alone advocate, was supporting the shifting of Madurai Court, because I want that even common man from corner of our state should represent before the High Court and be selected as an High Court judge because of his performance before High Court. I told in the general body meeting declaring that even the High Court at Coimbatore, Tiruchi is established, I will be welcoming. And there was heavy fighting between one group and me, and I was brutally assaulted by Karupan along with his inmates, and resulting some eye problem for long days. When I filed contempt application, Justice Karpagavanayagam told, forget about everything, Krishnamurti. He was best friend of me, not only friend, guide. So I accepted and withdrew the complaint, because after all Karpan is my best friend. Whenever he leave India for foreign countries, he directed me to look after his family members. All these things had happened. So that time what had happened, all the agitating advocates claims that we will have no work. See what is happening in Madras. Madurai people heavily work. Here is also heavily work. Courts are crowded. You cannot decide as you are thinking, whatever you in mind sits in mind. Whenever any good proposal is being implemented, you started racing without any substantial grounds, analytical grounds, statistical grounds, informative grounds, and simply claiming that this is not correct, this is fundamental rights violations, nonsense, whatever. And this is filed, a writ petition was filed under Article 32, violation of fundamental rights. But the court did not accept it. Therefore, see, this is what when this judgment is applied, Supreme Court, I want the Supreme Court Chief Justice to concentrate why you are not bifurcating and arranging at least circuit benches at Bangalore, Calcutta, Chennai, or somewhere in Rajasthan, so that people will not rush to Delhi. And practicing at Delhi is a very brave practice, because I had an experience that several Tamil advocates who are started practicing were being threatened by other gangs. And the judges, retired judges of Madras High Court are practicing very brilliantly and successfully also. That is very helpful and understanding. These things are what is happening in Delhi. By pressurizing the judgment, referring the judgment, the bar council members, contesting members may place one of their trump card to lure the votes, stating that if I become bar council member, I will see that the Supreme Court branch is opened at Madras. Just you are giving वादा जो वादा किया तो निभाना पड़ेगा. After elections, everybody forgot. Okay, best wishes.